Hello landlords, it's Ernie Garcia, landlord attorney. Today we're talking all about rent splitters, those occasions where you have multiple tenants living in one unit, but it's not a single person who's paying the rent. Multiple people are contributing to it, or maybe you're in a situation where the tenant who lives on the property isn't paying the rent at all. What do you do in these situations? What do I recommend in order to keep you out of a jam? Let's get started. So rent splitting happens in a variety of ways. And we're going to talk about different scenarios where even though you didn't intend for the rent to be split, you sometimes get a situation where you've got rent splitters on your hands. What do you do in those situations? So one common situation is when heartbreak sets in. Maybe you started off with a couple, both of whom signed a lease, who were married at the time of the lease signing, or maybe just dating, but they were a romantic couple at the beginning of the lease term. Now, in the middle of the lease term, things are going south in this relationship, and these two simply can no longer, or just have decided to no longer live together. What do you do holding this lease? Remember, you're in the middle of the term, has not come to an end, but people are going to come to you and say, I'm no longer living here. I no longer owe you rent. What do you do in this situation? Well, first and foremost, it's important for you to know that you are not the referee of this relationship. Even though you are the landlord, it's not up to you to enforce the desire of one tenant to keep another tenant away. Remember, the fact that they signed the lease together and may be current on the lease means you can't really show a preference between one tenant and another. If a party is having difficulty with their partner and they're seeking to enforce certain rights that are not present in the lease, they're probably going to have to seek out the courts and see what, if anything, they can get in the way of maybe a protective order or some other mechanism that will allow them to stay on the property outside of the presence of the other tenant. But that's not something that you are set up to enforce, nor is it something within your landlord rights. The fact that the situation has changed between the partners doesn't mean that the lease terms have changed, unless all of the original parties to the original lease sign some kind of modification. But if that hasn't happened, again, it's not up to you to referee between the partners when they've decided to part ways. Along with the fact that you're not required to referee between them, you're also not obligated to release one of them. If, again, they both came in and both signed the lease, were both obligated at the beginning, and now one wants to leave, you're not required to release them. The fact is they're obligated from start to finish on this lease and probably should remain so. I don't recommend, especially if the second tenant is a little shakier or might not themselves qualify to stay on this property without the other partner. You're going to want them both on the lease in the event that you'll ultimately have to collect from both. By releasing one, you release their obligation, and therefore any of the any claim you might have against them for the time while they were in possession is probably closed, and you won't be able to collect anything from them once they have been released. So just because they ask doesn't mean you are required to do it. I'm going to give you a few strategies on how to deal with that later on in the video. But in terms of being obligated, it simply does not exist. Another thing that gets asked whenever there's a breakup is for that deposit. And the person leaving says, hey, I'm leaving. I want half of the deposit back. Well, there's nothing in the lease and nothing in state law that allows the tenant to demand half or any portion of the security deposit back while the lease is still active. The fact is there's no obligation on the part of the landlord to return a deposit until after a tenancy has ended and the tenants have in fact surrendered possession. In this case, only one tenant is surrendering possession. So because other tenants remain and because the lease is still ongoing, there's no obligation to refund anyone their portion of the security deposit. So what do you recommend, Ernie, that I do if I'm in this situation where I have one spouse who's on the way out and has asked for their deposit? Just follow the lease and inform the tenant, look, you're still under the same obligations under the lease. I will still issue a payment in both of your names, but that's really something you two have to work out between you both. That's not, again, you're not the referee. You're not there to kind of help them through this difficult time. In fact, all you're obligated, and really the only thing that you're allowed to do is to follow the terms of your lease and to follow state law. Now, if in your jurisdiction you have a higher degree of responsibility when it comes to partners breaking up like this, that's different. For sure in Texas, none of these rights exist. And I would consult with counsel in your area just to find out. I haven't heard of anything widespread across the country where just because of this situation, a landlord has to surrender any portion of the security deposit. Check, though, to make sure in Texas it's not a thing. Next, we have the college dropouts. You may live in a town where you've got younger people specifically attending college, but sometimes it happens that, different members of the household are at a different level in terms of their study, and maybe two of them are still, on board for another couple of years, but the other two are graduating, and this happens in the middle of the lease. What do you do if all of a sudden half of your rent-paying parties are on their way out? Well, you're probably going to want to get ahead of it and understand precisely how long everybody's going to need the lease. But remember, the fact is, they signed the lease all the way to the end, and their graduation doesn't necessarily give them additional rights that would otherwise terminate their obligations to continue to pay rent. So rent is still due even if a party is graduating or dropping out or going to a different school and no longer can reside on the premises. That's not your issue. So it's important for you to know who signed, and if all four, in this particular scenario, all four students signed, they're all still obligated. Where things get complicated is where one person signed as the team captain for this group, and you allowed that. I certainly don't recommend, whenever you have a group of adults in a unit and they're all contributing to the rent, or they're all able-bodied adults, it's different when someone is disabled or maybe extremely old and wouldn't be contributing financially because of that, or they're extremely ill. Those are rare situations, but when you've got four able-bodied adults, all of those adults should sign the lease, and all of those adults should be contributing somewhat to the tenancy, but they are all on the hook. If you let just one person sign and, that person is the one who leaves, the likelihood that the remaining three are going to have any obligation to you directly simply doesn't exist. They're not in privity. They didn't sign a contract with you. And so how well do you think they're going to treat the house if they know there's zero consequence against them as individuals? The only person who signed was the one who packed his bags and left. That puts you in a tight spot. I don't encourage that at all. But what is important to understand is the fact that your lease probably makes all of the tenants who sign jointly and severally liable, which means that if you're in a situation where you've got four college students, two of whom pay every time on time and two of whom always pay late, guess what? Those late fees are owed by all of them. In fact, the entire rent is owed by all of them collectively or individually. The fact is, you're not there to collect only 25% from each of four tenants. You're there to collect 100% of the rent from whichever tenant pays first. If it means they all pay an equal share, great, but that's not a requirement. If only two rent-paying tenants have paid half of the lease, guess what? All four of them are in default, and you should be issuing a notice to vacate to all of them. Now, you may say, well, Ernie, these other two are great. They always pay their rent on time. Well, the better question to ask is, if you got rid of just the second two, will the first two be able to pay the full amount of rent? If not, then it doesn't help you to keep those two because they're not enough. And so you're going to want to get rid of all of these tenants if, for whatever reason, two of them simply stop paying and the other two simply can't afford to cover that share. Now, you may be asked, listen, we've got two going out, but we've got two willing to come in and take their spots. Will you consider them? Now, this is something that happens from time to time. And if you have parties like this, my recommendation, and I'm going to talk next about a hard reset. My recommendation is that you scrap the original lease and sign a new one. Again, I'm going to get more to that in a second, but definitely make sure that you have screened properly the incoming tenants and make sure that the 4 remaining tenants by themselves meet up to your renting criteria. If they do not, if the 2 new ones coming in don't measure up to the 2 ones going out, and if you take them even as a collective, the 4 of them together don't pass your renting criteria, then I would say no, go find somebody else, or be prepared to cover the missing share, or you got to leave. So make sure the new situation that you enter into is actually one that works. But always, 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 and I've got one more scenario, but I want to talk to you about the hard reset. Once you've gotten rid of, or where you've got a split, and for example, you've got the heartbreakers that split up and are not getting back together. Well, what I would recommend is that you don't just keep that situation on indefinitely. Certainly, once that original lease comes to an end, make sure that if you're required to terminate it in writing, that you do, and don't just let the automatic renewal provision, let you coast for a while. I would bring that lease to an end. And if the remaining tenant is qualified to rent the unit by themselves, then I would sign a new lease, release the other, issue a security deposit back, just like the lease says, and then charge a new security deposit back in the new lease from the current tenant once you've terminated the first one, gotten rid of the party who's no longer there, and signed a new lease with the remaining party or parties who take the lease. So again, whether it's the breakup or whether it's the college kids, once that original lease comes to an end, I would, again, terminate it properly. If it has an automatic lease renewal, make sure that you send written notice that it will be terminated and a new lease will need to be signed by those who remain. That's the best way for you to do things, is to make sure that whatever the previous agreement was, it's come to an end. The previous security deposit has been returned in the name of all the original tenants, and then they amongst themselves have dealt with that, but a new security deposit in the name of the current tenants should be taken, and a new lease signed by all of the current adult occupants. However, if you're in a situation where things are looking badly or things have gone poorly since that transition, naturally what you're going to want to plan is, even if you could get by, if you can see very clearly that this person or the remaining people on the list simply can't get the job done, then you're going to want to move forward, make sure that you've sent the requisite notice to terminate lease, and then ultimately, if the tenant holds over beyond or becomes delinquent for non-payment of rent, that you're quickly moving forward with a notice to vacate, to go ahead and get rid of this particular tenant and put somebody in there who can actually afford the unit. Finally, I want to talk about free riders. These are situations that come up where the person who's actually living on the property isn't really paying for it. And this happens in a couple of ways. So the classic one is a young person who simply can't afford their living space, but mom and dad are fitting the bill. Or sometimes you have an older person and one of the children is paying the bills for grandma so she can live in your rent house. So what do you do in a situation where another party is actually paying the rent for an individual who is unemployed or unable to work for whatever reason, but is living on your property? Well, I would strongly recommend that you get that other party to sign as a tenant, or at the very least to sign a personal guarantee. This way, they are financially obligated to continue to pay. The fact that they're willing to pay, but that only the occupant is going to sign the lease, means you're probably undersecure, because you already know that individual doesn't have the funds to pay rent. They certainly wouldn't have the funds to pay any rent damages or legal costs that you would incur from a breach caused by them. Make sure that you're ready for such an occasion where you're going to have to sue, and make sure that the party who is able to pay is on the hook to actually pay should things go sideways. This also happens if in the middle of a tenancy, an otherwise good rent-paying tenant simply loses their job or becomes ill and is unable to pay rent, but has secured funding from local charities. Now, the problem with taking money from local charities is that charity money will eventually run out. Sometimes it's limited to a single month, and even if it does go on for a number of months, if it looks so bad for your tenant that it's unlikely that they're going to get back on their feet in a short amount of time, this is probably something you're going to have to consider in terms of non-renewal, in terms of termination, and in terms potentially of a notice to vacate if the funds simply stop coming. It's an unfortunate situation for someone who loses their job or suddenly becomes ill. But unfortunately, those situations don't necessarily create additional rights for the tenant. If rent remains unpaid, you have the right to collect it and should continue to enforce your rights under the lease. So if you're in a situation where someone's receiving charity, you're going to want to be ready and not wait extended periods of time in between charity requests. The truth is sometimes people are able to secure funding at first and then never again. And if you're just holding out hope that someone's going to come in and pay 2, 3, or 4 months of unpaid rent, the chances of that are usually pretty low. And by that point, you've probably waited way too long. Now, for those of you who are just starting out or maybe just don't have a whole lot of experience with the eviction process, I have an offer for you that we are making available to all of our clients, particularly for those in Texas. If you have rental property in the state of Texas and are issuing notices or would like to learn a better way to issue notices and file evictions and even handle eviction appeals in the state of Texas, then you may want to check out our eviction course. There's a link in the description below, but you can also check out attorneyeg.com/EV for more information on that eviction course. We walk you through the process of your notices, of filing, and even the kinds of things that you can expect at trial and on appeal. If you would like a course where we go step by step from notice to judgment to help you recover your property faster, I strongly encourage you to check out attorneyeg.com/EV, our Texas eviction course from start to finish. Again, I'm going to walk you through multiple modules. I give you samples of your notices, samples of an eviction petition, and plenty of resources along with my step-by-step training to help you file your own eviction with success. If you need more information, feel free to send us an email at info@attorneyeg.com and check us out at attorneyeg.com/EV for information on our Texas eviction course. So we know that the collection of rent can be complicated, especially if it's not one party who's paying the bill, but it's split amongst multiple parties, or the party who actually pays isn't the one who's actually living on the premises. These kinds of things can be complicated, but there are ways to navigate these situations well. However, at the moment that trouble strikes, we strongly encourage you to be on your game, to issue the right notices, and to proceed even to eviction if it's necessary to minimize your losses. I hope you've learned a lot from today's video. There's plenty of content on this channel for future viewing. In fact, right now, YouTube thinks this video right here is the next best thing for you to watch. I encourage you to watch it. And until next time, landlords, happy leasing.